that an appeal or a second appeal shall not operate as a stay of execution or proceedings under a decree or order appealed. So that the language used is shall, which is mandatory. Then secondly, and more importantly, my lords, under the rules as per the Constitution, it is anticipated that a party who wants to stay proceedings may in the first instance make an informal application upon the delivery of the ruling. So that in this case, the ruling was delivered in January and no such informal application was made then. And again, when a party does not choose to make that informal application, under the rules, it says one must move the court within 14 days of the decision they seek to challenge. That is under Rule 32.3, which says a formal application for stay may be filed within 14 days of the decision. So that in this case, the applicants are coming way late, over 2 months, my lords. Again, considering that the matter of stay is alive and pending before the Court of Appeal, again, the question of sub judice arises. So that there is an imminent danger again of two courts rendering different decisions over the same issues. Again, assuming this court was to grant stay, where does that leave practitioners and litigants in terms of certainty in light of Rule 32 of the Mutunga rules? So that is it that the rules will be applied selectively whenever a party desires, or is it that when we come to court we are certain because Rule 32 provides the procedure for such applications for stay? Again, the question of prejudice has been raised, and I submit the denial of stay by this court shall not in any way limit or take away the right of appeal of the applicants. Because the same will merely defer that right, considering this court is yet to make a pronouncement on merits of the petition, and all the parties still retain that right of appeal. And again, my lords, this is a three-judge bench matter, so that even getting 3 judges to sit and hear a matter is also problematic within the division, and not just Nairobi division. So that again, the law anticipates that a party can always move the court to arrest a judgment before it's rendered. So that I'll be praying that the court gives a date for hearing so that the court can hear us, so that whatever order shall come from the Court of Appeal, that shall inform the next course of action by the court. But in the meantime, I pray that the court gives an early date so that we can dispose of this petition. That's all, my lords.
To give any information that I deem it's important. My lords, a precedent has been placed before you, petition number 4 of 2019 from the Supreme Court, and you've been told that you need to take notice if a matter is pending. But my lords, a precedent is important for what it says. The scenario here under the Supreme Court, it was different. It was the Wiba matter. Justice Ojwang, as he then was at the High Court, went on to decide if the High Court it has jurisdiction or if the matter should go to the director, while the matter was pending before the Supreme Court. My lords, the question in this petition is the decision of the Speaker. That question is not pending before any superior court. Therefore, my lords, the short of it is that that precedent is inapplicable in this situation. And secondly, and to add as to what my colleagues have submitted on, appeals or pendency of appeals is not a ground or an order for a court to stay proceedings, there must be an order. There are precedents which cannot be rewritten, my lords. We cannot reinvent the wheel. Much obliged.
With that development, Your Lordship, noting that the 13th respondent and the 10th respondents are members of the second interested party whom I appear to. And they have looked at that affidavit.
I'm going to appoint a council for the real estate.
Thank you very much, judges. My name is Mondara. I would like to record what an advocate representing the first respondent and the 17th respondent. Yeah.
Right, so these are our directions. This petition was slated for highlighting of submissions today. However, two counsel brought to our attention what they have described as cross petitions, and on which they sought directions before we take the highlights of the submissions that have been filed in respect of the petition. Mr. B.M. Mungata informed the court that he has a cross petition dated 17th April 2024, purportedly filed by one Caleb Mutiso Mule and one Ekomas Mwangi Mutuse. Mr. Dudi, counsel for the 9th interested party, informed the court that he has a cross petition dated 16th April 2014, The Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedure Rules 2013, popularly referred to us as Mutunga Rules, provide for cross petitions. Rule 15, Sub-Rule 3 of those rules says as follows, I quote, "The respondent may file a cross petition which shall disclose the matter set out in Rule 10, Sub-Rule 2. A plain reading of this rule is that it is only a respondent who can file a cross petition. An interested party cannot, neither can a stranger to the petition who is not named in the petition in any capacity, can purport to file a cross petition. It follows that the purported cross petitions, respectively dated 17th April 2024 and 16th April 2024, are a nullity and they are hereby struck out. That being the case, no directions can be given on nullities. The second issue that has been brought to our attention is that several appeals have been filed against the decision of this court handed down on 26th January 2024. An application has been filed in the Court of Appeal, being application number E119 of 2024, for stay of these proceedings. But the application is yet to be heard and determined. Ms. Guserwa, the learned counsel for the third and fourth respondents, and Mr. Milimo for the sixth to ninth respondents, have asked us to stay these proceedings pending the hearing and determination of the application before the Court of Appeal. Rule 32, Sub-Rule 2 of the Mutunga Rules provides for stay of proceedings. It states as follows: an application for stay of execution may be made informally following the delivery of judgment or ruling, and the court may issue such orders as it deems fit and just. And Sub-Rule 3 of the same rule says, a formal application may be made or may be filed within 14 days of the decision appealed from, or within such a time as the court may direct. Although the rules appear to focus on stay of execution, we are of the opinion that the rule applies by necessary implication to any other proceedings in the petition for which a stay is sought. We say so because there is no other rule in the Mutunga Rules. No application was ever made for stay of proceedings. Informally, immediately after the delivery of our ruling of 26th January 2024, or formally within the time prescribed by the rules. Secondly, this court has not been served with any order from the Court of Appeal staying these proceedings. For these reasons, we see no reason why we should not proceed with the hearing and determination of this petition. The last issue is a request by some of the respondents and interested parties seeking to file supplementary submissions because they were served late with the petitioner's submissions. Mr. Kibe, the learned counsel for the petitioner, has admitted that indeed submissions were filed and served late. and in any event outside the timeline prescribed by the court. In order to give the respondents and interested parties sufficient time to consider the submissions filed by the petitioners, and if need be, they file supplementary submissions, we shall adjourn the hearing of this matter for highlighting of submissions to 28th June 2024. In the meantime, the supplementary submissions, if any, shall be filed and served within 14 days of the date hereof. Further, the replying affidavit filed by the 13th respondent is hereby deemed as duly filed and properly on record. And for that reason, the 2nd and 11th interested parties are granted leave to file a further affidavit in response to the 13th respondent's affidavit. The same will be filed and served within 7 days of today's date. Those are our orders and directions. Petitioners, we have 14 days to file and serve supplementary submissions in response to the submissions filed by the respondents and interested parties. Those submissions will be filed and served within 14 days of the date of service of the submissions by the respondents and interested parties.
Briefly,
We are not opposed to that.
the said appeal against the vote.
Number one is that the court having made a decision that there is no locus standi for the filing of a cross petition, it effectively means that there is no legitimate cross petitioner who can apply for leave as provided in the Mutunga rules. Number two, would be that the timelines for the filing, at least from the view of the petitioners, having expired, having lapsed, the time for filing of a response and a cross petition, and the directions having been given for the hearing of this matter, which has largely been undertaken through the written submissions, it would be a gross abuse of the court process for such stay to be granted. And finally, that they have not even bothered to say what prejudice they would suffer in the event that that stay of proceedings is not granted.
Methodist Church of Kenya versus Fugisha, a decision of the Supreme Court, which is binding by dint of Article 163(7) of the Constitution. So there is no legitimate issue upon which an order of stay may be granted. I'm most obliged.
All right. The person seeking to have the so-called cross petition filed or directions taken on the filed cross petition are not even parties to this petition. As for the interested party, who is named as such, he has the liberty to file his own petition that can be considered by the court at the appropriate stage. So for those two reasons, we dismiss the application for stay of the proceedings. You'll be given the ruling. It wasn't typed. Yes, it was by longhand. So if there is no other business, we can adjourn.
Now today we were coming for the hearing of the petition that is questioning three main issues. Number one, it is questioning the ruling of the Speaker of 6th of October 2022 to the effect that Kenya Kwanza is a majority party, despite the fact that in the same ruling, the Speaker acknowledged the fact that in accordance with the declared result, Azimio had 171 and Kenya Kwanza had 164. And therefore, the petitioners say that his Speaker Wetangula effectively was overthrowing the Constitution and declaring a minority party to be the majority party. That is the first issue. The second issue is the questions to do with the efforts by the Kenya Kwanza coalition to destabilize other political parties, to destabilize and subvert multi-party democracy in Kenya, and it has taken the predominant form of ensuring that the Jubilee Party is so disorganized that it is not an effective party to represent the people who voted for it. For the people, particularly from the central Kenya regions, who voted for Jubilee, it has effectively meant that everywhere else in the Republic of Kenya, you have multi-party democracy, but when it comes to central Kenya, Kenya Kwanza want to have single-party democracy, which is unconstitutional, because the Constitution declares that all citizens of Kenya must live under multi-party democracy. This is being undermined in central Kenya, and it is part of the reason why the attempt to dissolve Jubilee Party so that Jubilee Party can join Kenya Kwanza is being resisted. The third issue that is being raised here is the fact that Speaker Moses Wetangula, despite the fact that he has a duty to be impartial and not to be an active politician, he has decided to defy the constitutions and conventions on how parliaments and speakers across the world are supposed to behave. And it is a petitioner's case that he is doing this in order that he can work as a political agent of Kenya Kwanza to ensure that parliament as an institution does not serve its role, constitutional role, for the people of Kenya. We should remember that this question of who is majority and who is not has had the effect of ensuring that last year, a party that was a minority was the main player in the budget-making process. We, the petitioners, are trying to say that you cannot countenance a situation in which a minority party, because of its constitutional control of the various committees of parliament, makes another oppressive budget through the ongoing budget process. The court has dismissed various attempts to try to ensure that this case will not proceed before the High Court, but because of the late filings of certain court papers, we have been given the 28th of June this year for purposes of conducting this hearing by way of highlighting of submissions. But in the meantime, the attempt by some other parties sponsored by Kenya Kwanza to come and join so that they can frustrate this case has been declared as unlawful because of the passage of time. Therefore, it is our hope that because we have other proceedings that are going on in the Court of Appeal, that the Kenyan judiciary will understand the literal game that is being played to ensure that petitioners, after filing their cases, you are suddenly finding a situation, just like it was during the dark days of multi-party, of Moi and Nyayoism, where petitions would be filed but were never heard. We hope that the judiciary will ensure that once petitions have been filed, they are actually heard and determined on merit. Mr. Lempaka.
108 ya katiba ndio wamekuwa wakiendesha hafla hiyo bungeni, na hivi ni kumaanisha kwamba mambo yote ambao wamekuwa yakifanya kama vile mwenzangu amesema ya kupitisha bajeti na kupitisha hata sheria zenye zinalete mtafaruku katika nchi kwa sababu ya zile taxes tunalipa ushuru, zimekuwa zikiletwa na bunge ambalo ni gushi. Na kama wakili aliposema katika mahakama, ukiangalia ibara ya 3, mtu yeyote ambaye anajaribu kuunda serikali kinyume na katiba anajaribu kuipindua katiba. Na ndivyo tumesema kwamba hata ingawa kesi hii imeahirishwa mpaka tarehe 28, hiyo ni miezi miwili. Subra ikitumika miezi miwili ni kama siku 2, na tarehe 28 tutakuwa hapa na tunatumaini kwamba tutawasilisha yale mambo ambayo tunasema kwamba Wetangula hana nguvu yoyote ya kusema ni nani kiongozi wa wengi katika bunge. Mtu ambaye angeweza kusema ama anaweza sema ni yule mwenyekiti wa IEBC, Bwana Chebukati. Alisema Ruto ndio aliyechaguliwa kama rais, na Chebukati ndiye alisema ni chama kipi ama ni muungano wa vyama upi uliokuwa na wabunge wengi, na walikuwa 171 dhidi ya 164, na Wetangula alipindua katiba ya Kenya. Na tunasema hiyo hatuwezi kumkubalia mtu mmoja kupindua katiba ambayo ilipigiwa na watu zaidi ya milioni 20 kura mwaka wa 2020. Asanteni.
Thank you.